Let's take a look at a key case within the law of tort. This is a case of Day and High Performance Sports Limited in 2003, and this is a case concerning the tort of negligence. Take a look at the facts of this case. The claimant was Mrs. Day. She was a 26-year-old postgraduate who was engaging in some top rope climbing. The facts of the case were that the claimant fell from a wall in an indoor climbing centre which was run by the defendant business High Performance Sports. The claimant suffered severe brain injury as a result of the incident, and a claim was brought by her father on her behalf. The claimant discovered, when she was around 25 to 30 feet high on the wall, that her top rope was not secured and therefore she was not safely attached to the wall. She called out to a nearby climber to try and assist her with her rope, but he was not able to, by which time the duty manager became aware of the situation and realised that the claimant was beginning to go into severe panic and that she would not be able to continue holding onto the wall in order to maintain her own safety. In the panic of the moment, and with not a lot of time available in order to come up with a plan about how to save her, the defendant employee told the nearby climber to try and grab hold of the harness. During this attempt, she fell to the ground and suffered severe injury, and a claim was made in negligence against the company running the indoor climbing centre. The outcome of the case was that the defendants were found not to be liable, and this was because there was no breach of duty. It was not in dispute that the defendant owed a duty of care to the climbers and the participants at the centre. However, when looking at whether the actions of the defendant in asking a fellow climber to try and take hold of a harness amounted to a breach of duty, it was concluded that, whilst it was an error, because it was found that the actions would not have been capable of preventing her from falling, this was an error of judgement and not of negligence, and they considered that the circumstances, which were an urgent and emergency situation, meant that the actions were not sufficient enough to satisfy a breach of duty. This is an example of actions not amounting to a breach of duty due to the emergency situation that occurred.